When judges conspire with others to violate your rights, they can lose immunity and be sued under 42 U.S.C. Section 1985. But filing a lawsuit isn't enough. You have to prove a conspiracy in court. So how do you do that? Let's break it down. Under federal law, a lawsuit alleging conspiracy under 42 U.S.C. Section 1985, 3, must prove 4 key elements. 1. A conspiracy. 2 or more people must have agreed to act together. 2. Intent to deprive rights. They must have targeted you with the intent to violate your constitutional rights. 3. Overt acts in furtherance of the conspiracy. They must have taken actual steps, such as issuing false court orders, falsifying records, or blocking your access to justice. 4. Resulting harm. You must have suffered harm, such as losing custody of your child, being denied due process, or facing retaliation. A conspiracy means 2 or more people agreed to violate your rights. But conspiracies don't usually come with signed contracts, so how do you prove one? If you miss even one of these elements, your case could get dismissed. So let's go deeper into how to prove each one. Look for coordinated actions. Did multiple officials act together to deny you a right? Find circumstantial evidence. Emails, text messages, or patterns of unusual behavior can expose coordination. Identify common motives. Was there an effort to silence, punish, or financially benefit from harming you? You must show that the people involved intended to violate your rights, not that they just made a mistake. Courts will look for unfair treatment, lack of legal justification, and retaliation patterns. A conspiracy claim needs more than just talk, it needs action. You must prove that the conspirators took steps to achieve their goal, such as issuing fraudulent court orders, altering or destroying evidence, refusing to follow legal procedures, or blocking access to justice. Even if you prove a conspiracy, you must show how it harmed you. Courts will look for loss of rights, financial or personal damage, and long-term consequences. Without a clear injury, your case could be dismissed, even if a conspiracy happened. Now that you know what to prove, let's make sure your complaint is strong enough to survive in court. Here's how. Be specific. Name who did what, when, and how. Vague accusations will get dismissed. Provide evidence. Attach emails, affidavits, transcripts, or other proof of the conspiracy. Show a clear timeline. Courts want to see a chain of events connecting the conspirators. Cite case law. Use Dennis v. Sparks, 1980, to show that judges in conspiracies lose immunity. Judicial immunity does not protect conspiracies. Dennis v. Sparks, 449 U.S. 24, 1980. Judges typically enjoy absolute judicial immunity. This means they can't be sued for decisions they make from the bench. The idea behind this is simple. Judges should be free to make rulings without fear of being sued. But does this immunity apply when a judge actively participates in a conspiracy to violate someone's constitutional rights? Let's examine the Supreme Court cases that say no. The Supreme Court case Dennis v. Sparks addressed a situation where a judge was bribed to issue a wrongful court order. The plaintiff sued not just the judge, but also the private individuals who conspired with him. The Supreme Court ruled that judges can't be sued for rulings made in their judicial capacity, even if those rulings are later found unconstitutional. But what this case did not address was whether a judge could be held liable if they conspired with others to violate rights. Pearson v. Ray is important because it showed that judges can be challenged in court, especially when their rulings systematically violate constitutional rights. In Pulliam v. Allen, the Supreme Court ruled that government officials, including judges, are not immune when they act outside the scope of their authority. This principle applies directly to judges who step outside their judicial role to engage in a conspiracy. Schuer v. Rhodes held that if a judge joins a conspiracy to deny due process, block access to the courts, or retaliate against a litigant, then that judge is no longer acting as a judge. They are acting as a co-conspirator and can be sued under federal law. Judges should be independent, but they are not above the law. If a judge takes part in a conspiracy to violate rights, they can and should be held accountable under federal law. Know your rights, hold the system accountable. And never let judicial robes hide corruption. If you've been a victim of judicial misconduct, don't stay silent. Fight back using the law. Stay informed, stay empowered, and let's hold the judiciary to the standards they were meant to uphold.